thank you for the floor. Thank you for the invitation to the seminar. It's an honor for me to be here. And I will continue to walk you through some decisions, some rulings, throwing a light on the question of independence, necessary independence, and preliminary references of national courts. Mostly in the courtroom, judge decides in his discretion, but we should be aware about the individual judge. There are others to judge him in the case of disciplinary proceeding. So the legal cornerstones were already mentioned in the EU law, that is namely Article 2 of the Treaty on the European Union, holding the common values, inter alia rule of law, respect for human rights, and what the European Court of Human Rights always emphasizes, the fundamental premise that all member states share these same values at the same level. Next, Article 19 of the Treaty of the European Union, the obligation of member states to establish effective judicial protection.
I think somebody's mic is on. Maybe you should ask them to turn off. We can.
I don't know who to address.
There is one who is on.
Please mute your microphones. Thank you. No? Okay, I will simply speak louder. I will try. So, and the member states have to establish a system of legal remedies and procedures for effective judicial review. Still the European Court of Human Rights quotes the general principle of effective judicial protection of individual rights stemming from common constitutional traditions of member states. That's an old phrase from rulings before the Charter entered into force, but still then I asked myself, what are the common constitutional traditions of member states in the European Union? Maybe the Court of Justice had a phenotype before his eyes, so the ideal, popping up, no? A phenotype of a member state with fully independent judges, with a legal system granting full judicial review and so on. And last but not least, and this is our key provision, Article 267 of the Treaty on the Functioning of the European Union. The court says that it establishes a dialogue between itself and national courts. So, then step into some decisions dealing with the tensions between necessary judicial independence on the one hand and the right and the obligation of courts of member states to exercise their discretion. The first case is a Polish case dealing with the lowering of retirement on the one hand, retirement age on the one hand, and granting the President of the Republic to extend judicial activity on the other hand. The court held there, in particular the judicial system has its keystone, the preliminary ruling procedure provided in Article 267, which by setting up a dialogue between one court and another, specifically between the Court of Justice and the courts and tribunals of the member states, has the object of securing the consistency and the uniformity in the interpretation of EU law, thereby serving to ensure its full effect and its autonomy, as well as, ultimately, the particular nature of the law established by the treaties. The principle of the effective judicial protection of individual rights under EU law is a general principle of EU law. In the next step, the court explains his model of independence of courts. The first aspect is of external nature. maybe external influences on the court, on the functioning of the court. The second aspect of independence is of internal nature. Judges are unbiased, impartial to the parties. The requirement of independence means that the rules governing the disciplinary regime and, accordingly, any dismissal of those who have the task of adjudicating in a dispute must provide the necessary guarantees in order to prevent any risk of that disciplinary regime being used as a system of political control of the content of judicial decisions. So, in the next ruling, the Court of Justice dealt with the establishment of the disciplinary chamber at the Supreme Court and its jurisdiction. There, the European Court of Justice repeated again that the system of request for preliminary ruling is a keystone of the judicial system in the treaties. Article 267 gives the national court the widest discretion in referring matters to the court. It is settled case law that the rule of national law cannot prevent the national court from exercising that discretion or complying with that obligation, which are an inherent part of the system of cooperation between national courts on the one hand and the Court of Justice on the other hand, established in Article 267. So provisions of national law, which national justice judges to disciplinary proceedings as a result of the fact that they have made a reference for a preliminary ruling to the Court of Justice, cannot there be permitted. The mere prospect of disciplinary proceedings as a result of making such a reference or deciding to maintain that reference after it was made is likely to undermine the effective exercise by the national judge. And in the present case, the court held that the definitions of the disciplinary offense do not meet the requirements under Article 19 of the Treaty on the European Union, since they give rise to the risk that the disciplinary regime at issue might be used or misused for the purpose of creating, in respect of judges from the national courts, pressure and a deterrent effect, which are likely to influence the content of the judicial decisions which those judges are called upon to give. So the next case is not a Polish case. Republika, I think it came from Malta, doesn't deal with disciplinary proceedings, but more with the question of separation of powers and appointment of judges and whether that touches the independence of judges. The independence of judges of the member states is of fundamental importance of the EU legal order in various aspects. It is thus essential to the proper working of the judicial cooperation system embodied by the preliminary ruling mechanism under Article 267. In that mechanism may be activated only by a body responsible for applying EU law which satisfies, inter alia, that criterion of independence. It forms part of the essence of the right to effective judicial protection and fundamental right to a fair trial as provided also in Article 47. While Article 47 of the Charter has to ensure respect for the right to effective judicial protection of any individual right, the second subparagraph of Article 19 TU seeks to ensure that the system of legal remedies established by each member state guarantees effective judicial protection in the field covered by EU law. The principle of separation of powers, which characterizes the operation of the rule of law, the independence of the judiciary must in particular be ensured in relation to the legislature and to the executive. In that regard, judges should be protected from external intervention or pressure liable to jeopardize their independence. The mere fact that the judges concerned are appointed by the president of a member state on the proposal of the committee does not give rise to a relationship of subordination of those judges to the latter or to doubts as to the judge's impartiality. If once appointed, they are free from influence or pressure when carrying out their role from the executive branch. In that case, the court accepted the establishment of a so-called judicial appointment committee as an improvement of independence of judiciary. The next case deals with the question of reorganization of courts, transfers of judges, and the impact on influence. The requirement that courts be independent, which follows from Article 19 TEU, has two aspects, as mentioned before, the external in nature and the internal in nature. The requirement of judicial independence requires that the rules applicable to transfer without the consent of such judges present, in particular the necessary guarantees to prevent any risk of that independence being jeopardized by direct or indirect external intervention. It is important that such measures of transfer may only be ordered on legitimate grounds, in particular relating to distribution of available resources to ensure the proper administration of justice. So in the present case, the Court of Justice accepted the system of transfer of judges following from the reorganization of courts. Well, but we also have in member states other kinds of institutional limits for preliminary references or to adjudicate on the ground of the answers of the Court of Justice. The first case is a relatively old Italian case, Polidienica, and had in the focus the system of reference of a chamber to a plenary session following after the end of the Court of Justice. The court held in this ruling a chamber of a court of final instant must, if it does not concur with the position adopted by decision of that court sitting in plenary session, refer the question to the plenary session in the Italian system, and is thus precluded from itself making a request to the Court of Justice for a preliminary ruling. Both that discretion and the obligation are an inherent part of the system of cooperation between national courts and the Court of Justice established by Article 267. Where a national court before which a case is pending considers that the question concerning the interpretation or validity of EU law has arisen in that case, it has the discretion or is under an obligation to request a preliminary ruling from the Court of Justice. National rules imposed by legislation or case law cannot interfere with that discretion or that obligation. Article 267 must be interpreted as precluding a national provision that where a question concerning the interpretation or validity of a rule arises, a chamber or a court of final instance must refer the question to the plenary session and is thus precluded from itself making a request to the Court of Justice for a preliminary ruling. So the next case is a recent case decided in July of this year, Han Invest, a Croatian case, where Supreme Courts had register offices, evidentiary offices, and I remember when I took part at twinning projects in Croatia, I saw that kinds of institutions, and my first thought, that are the kind of evidence bureaus as we have it in Austria, but they were totally different. Our evidence bureaus in Austria have the task to publish decisions, make it available for all. The registration office in Croatia had the task, if a court, a panel of the Supreme Court adopted a decision, then it had to send it to the registration office, where a judge in the registration office reviewed it, whether it's in compliance with the settled case law of the court or not. And that can even limit the competence, the discretion of a panel, well, to adjudicate following to answer from the Court of Justice. And in that case, the Court of Justice held again that such a system, an internal national system, which hinders a panel, for example, to issue its ruling after a preliminary ruling of the Court of Justice, is not in compliance with Article 267 of the Treaty on the Functioning of the European Union. The Croatian system had a second step, that the judge in the registration office could demand that the case is reported to the plenary assembly of the court. So that would mean that in the next step, judges would also decide on that case, which were not first members of the panel. And the Court of Justice saw in this enhancement of the panel all the violation of Article 47 of the Charter. So all these limitations, the Croatian system, were judged as inadmissible. And last but not least, I think it's a Romanian case, also recent from September of this year, that the Romanian legal system provided the binding effect of rulings of the Constitutional Court for national courts. And the National Court, after a preliminary ruling, which had to be followed, could be in conflict, on the one hand, to judge following the preliminary ruling, or to be bound to contrary case law of the Constitutional Court. And to make it brief, because our Romanian colleague maybe also referred to that, the Court of Justice held over here, following from Article 267 of the Treaty on the Functioning of the European Union, the National Court, having exercised his discretion, must, if necessary, disregard the rulings of a higher national court if it considers that they are not consistent with EU law, if necessary, refusing to apply the national rule requiring it to comply with the decisions of the higher court, even if the pain of disciplinary proceeding incurred by national laws. So, of course, all these rulings give us a high level of independence, a high level of discretion, but at the end, when this independence is limited, or this independence is threatened by disciplinary proceedings, who has the independence to bring that to the Court of Justice or to the European Court of Human Rights? And, well, we saw if disciplinary proceedings can cut national judges away from union law, from the convention, then the necessary link between union law and the national legal system gets lost. So thank you for your attention. And last but not least, as I am also a member in the Consultative Council of European Union, only two opinions I want to mention. The first opinion of 2006 on the role of national judges in ensuring an effective application of international law. So it's nearly 20 years old, and at that time, the risk for judicial independence was not a topic. That was more focusing on supporting judges to apply union law and to make references to it. At present, the Consultative Council or the working group works on the next opinion on disciplinary liability of judges. It should be adopted in December of this year, so it's not yet published, although the working paper is not yet. But I'm optimistic that although this opinion will have a recommendation on the issue of preliminary rulings on the one hand and disciplinary procedures on the other hand, and the necessary independence for that. Let's look at it. Thank you.